Oui, parfait, parfait. Bonjour à tous.
Hello, everyone. I call this meeting to order. Welcome to the 25th meeting of the House of Commons Standing Committee of Official Languages.
Is a hybrid format and members will attend in person or with the Zoom application. À la lumière des recommandations des autorités.
Given the ongoing pandemic situation and in light of the recommendations from the health authorities to remain healthy and safe, all those attending the meeting in person should follow the directives of the Board of Internal Economy. I thank members in advance for their cooperation.
Challenges arise. Please advise me immediately. Please note that we may need to suspend a few minutes as we need to ensure all members are able to participate fully. Donc, conformément à
Pursuant to the order of reference from Monday, May 30th, 2022, the committee commenced consideration of Bill C-13, an act to amend the Official Languages Act to enact an act respecting the use of French in the course of business in federal jurisdiction and to make related amendments to other acts. I would like to welcome our witnesses. I had a hand up for Mr. Drouin. Drouin, hello. I want to maintain the spirit that we discussed since April. I would like to present a motion that speaks to today's study. I want to read it in for the record, and I think we'll be able to distribute it after. The interpreter does not have the text. As part of the study of C-13 that speaks to the use of French in federally regulated industries, the Minister of Official Languages, the Minister of Heritage, and the Treasury Board Minister and IRCC should appear. The Official Languages Commissioner should be invited to appear on Wednesday, June 15th, 2022. The clerk invites witnesses to appear during the meeting on the weeks of June 6th and June 13th, 2022. Amendments to Bill C-13 be submitted to the clerk in both official languages no later than 12 p.m. Eastern Time on Friday, June 17, 2022, or 48 hours before the start of the clause-by-clause review of the bill, whichever comes first. And E, the committee commence a clause-by-clause consideration of the bill no later than Monday, June 20th, 2022 at 3:30 p.m. F, if the committee has not completed the clause-by-clause consideration of the bill by 5:30 Eastern Time on Tuesday, June 21st, 2022, all remaining amendments submitted to the committee shall be deemed moved. The chair shall put to the question forthwith and successively, without further debate, on all remaining clauses and proposed amendments, as well as each and every question necessary to dispose of clause-by-clause consideration of the bill, as well as all questions necessary to report the bill to the House and to order the chair to report the bill to the House as soon as possible. Stay with me, friends. I'm almost done. G, the clerk of the committee write a committee to each member who is not a member of a caucus represented on the committee and any independent members to inform them of the study of Bill C-13 by the committee and to invite them to prepare and submit any proposed amendments to Bill C-13 which they would suggest that the committee consider during the clause-by-clause study of the bill and, as agreed on Wednesday, June 1st, 2022, subject to the approval of the recognized parties' whips and the availability of meeting slots from the House of Commons, the committee hold as many additional meetings as possible with the goal of accomplishing a maximum of 15 hours of study prior to the beginning of the clause-by-clause consideration of the bill. Mr. Chair, this is the end of the motion. But I know that my colleague has also presented a motion, and I'd be open to include the Director of Parliament in this if we have to move forward. Thank you, Mr. Drouin. Are there any questions as to the motion? Mr. Godin. Well, Mr. Chair, we have not received a copy of this motion. Is that possible? Because our colleague read it, but you understand that there were many elements in this motion. And from what I understand is that we're trying to accelerate the process. I don't necessarily I don't agree with this way of doing things, who's representing the party in power. But this party has been in power for 7 years. And now this bill that was tabled on March 1st was discussed last week, and we're being bulldozed over and over. And this bill is very important for official languages. And I think we have to take the time to do the job right. We have limits in time. I will wait for the printed document, and I will make more specific comments after that. Thank you, Mr. Godin. While we wait for that, I will hear from Mrs. Ashton and then Mr. Beaulieu. Mrs. Ashton. Hello, everyone. First, I find it very concerning that all of the members of the committee did not receive this motion in advance. I think we're all here working in good faith to move as quickly as possible. On our side, we would like to add more hours. We want to hear from key ministers and key points of view. Of course, we've just submitted a list of witnesses. We think that we should invest more hours in this study. There are certain parts at the start of the motion that we can work with. But there are many parts of this motion that we find unacceptable. They limit our ability to do the democratic work that we have on this bill. Just before Mr. Drouin, then first Mr. Beaulieu, I think we're supposed to receive motions in advance, so we can't vote on it right now. Well, this is part of the study. We don't have a 48-hour notice period when there are motions relating to a specific study. I think this is unbelievable. We're being muzzled, rushing through the second reading, no debate, and this is a major bill that will have a major impact on francophones in Quebec. There is much work to be done on this bill for it to be acceptable for Quebec, and I don't understand why they would try to bulldoze a bill like this. I think this was delayed and delayed and delayed. We've been talking about it for years, and now all of a sudden it's like go, 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 second reading. It's June 7th. It gives us 2 weeks to study it. We have to go through everything, hear from all the witnesses. There's so many bills. I think this is unbelievable. This makes no sense. We should take the time to do this properly. Like we said in the last meeting, I don't know if we can bring up old motions, but I thought we had agreed that we were going to hear from witnesses. And then worst case scenario, in September, we would do a clause-by-clause study. I think this makes no sense. Mr. Drouin, and then Mrs. Ashton, is your hand still up, or did you forget to take it down? Nope, I raised my hand again. So Mr. Drouin, Mrs. Ashton, and then Mr. Généraux. Mr. Drouin, I'd like to remind members of the committee that in April, we asked to do a pre-study, and the answer was no. I presented another motion that was similar. You said no, and then we closed the debate. And now I'm being accused of trying to steamroll the committee. 15 hours in committee is 5 weeks. And that's without the clause by clause. So we will have dedicated 6 to 7 weeks worth of work in 2 weeks. You know, a minority government is never secure. Official languages minority communities are asking us to adopt this bill as quick as possible. Yes, there will be amendments, etc. But if we don't enforce timelines, I can tell you that we'll still be here in December discussing different dispositions and hearing the same things over and over. All of the witnesses will say the same things. And unfortunately, it's my community back home that will pay the price because we're refusing that C-13 be adopted in the House of Commons. I have enough experience to see that some tactics are being employed. I find this deplorable, but I'd like to remind you that I'm looking for 15 hours. I'd like to remind you that this is the equivalent of 5 weeks of work, and this is without counting the clause-by-clause work. So it's a 6 or 7 week equivalent. Let's not think that we're not trying to hear from witnesses. This is the point I'm trying to make. We wouldn't be having this conversation if we had adopted Mr. Serre's motion that was made in early April. Point of order, Mr. Chair. Point of order? Mr. Godin. You know, Mr. Chair, I don't appreciate my colleague who's attacking us for decisions that were made in the past. This is not a point of order. I'm so sorry. You know, rules go both ways. I have Mrs. Ashton, then Mr. Généreux. I think we all participated in the conversation last Monday. We discussed what we wanted to work on in the coming weeks. I'm looking forward to hear from you, Mr. Chair. What are our options to add hours? I'm not looking for theoretical possibilities, but tangible ones. You sent us an email requesting more availabilities. I accepted them. I think as a committee, we need to know what we're working with. Based on the conversation we had last week, and to have the power to add hours, I would like to propose an amendment to the motion. We would keep Part A, the invited ministers, Part B with the official languages commissioner, Part C, that we hear from witnesses on the weeks of June 6th and June 13th, that we eliminate Part D, E, F, G, and as for Part H, that we eliminate the reference of 15 hours and that we let it say that as agreed on June 1st, 2022, subject to the approval of the recognized parties' wits and the availability of meeting slots from the House of Commons, the committee hold additional meetings. I think this is a good reflection of our desire to have more hours to do this work without steamrolling the process. And if we're talking about timelines here, let's be clear. The government promised to present this bill in its first 100 days in power. This didn't happen. We're now working with the government's timeline. We're hoping to add hours to do a good job with this, to do good work without being limited in our ability as a committee to improve this bill. Mrs. Ashton has proposed an amendment, so now we have to focus on the amendment. Mrs. Ashton, I don't want to make you work too hard, but can you summarize what you said? Everyone has a copy of the document in front of them. So you're saying keep parts A, B, and C, and then eliminate parts D, E, F, G, and then for section H, we would eliminate the mention of the 15 hours of study. So the rest would read as follows. As agreed on Wednesday, June 1st, 2022, subject to the approval of the recognized parties' whips and the availability of meeting slots from the House of Commons, the committee shall hold additional meetings. And we would eliminate the mention of 15 hours. So Mr. Gould and Mr. Godin would like to speak to the amendment, and then Mrs. Latanzio. Mr. Gould. One moment, Mr. Gould. For those of you who are looking at me who had their hand up, since this is an amendment, we start the speaking list from scratch. So now we're only talking about the amendment that was brought by Mrs. Ashton. Mr. Gould and Mr. Godin have their hands up. Mr. Gould, go ahead. Thank you, Mr. Chair. I would like to join my voice to this. We want to work on this bill. This is a historic bill that's been 50 years in the making. I don't think we should rush through it in 2 or 3 weeks. I think this would be a shame, and it will be a shame for all Canadians because it will likely be in place for the next 50 years as well. I have a sub-amendment, but I have some areas of agreement with Mrs. Ashton, but in D, I would like to take out the notion of noon on Friday, June 17th for the clause-by-clause review. This is problematic. Mr. Gourde, I'm so sorry to interrupt you. The proposal says that we would eliminate D. It's not there anymore. Oh, I don't have the proposal in front of me, so I have my notes here. So if there are some areas that are the same, that's fine. I would remove E, remove F, no immediate call to a vote. The clerk is telling us that within a few seconds, we will all have the proposed amendments that were made by Mrs. Ashton. What you just said is important, but these have already been removed. If you have any questions on this, we'll come back to you. But first, Mr. Godin. Mr. Chair, I would like us to adjourn this debate so that we can hear from our witnesses. We want to work on C13. I think we should hear from our witnesses, and I'd like to adjourn the debate. So this is a non-debatable motion. We will move to a vote. So we're adjourning the debate on the amendment. And then I'll adjourn the debate on the motion after. So for everyone who's watching virtually or in person, Mr. Godin is asking us to adjourn the debate on the amendment proposed by Mrs. Ashton. We're moving to a vote.
Monsieur Iacono. Monsieur Iacono.
Excusez-moi, non.
Madame Kayabaga. On ne vous entend pas, malheureusement. Probablement le bouton sur votre casque, sur le fil du casque d'écoute.
Je m'excuse, je vote non.
Merci. Madame Latanzio.
Non.
Madame Lalonde.
Non.
Monsieur Godin.
Oui.
Monsieur Gourde.
Oui.
Monsieur Lehoux.
Oui.
Monsieur Généreux.
Oui.
Monsieur Beaulieu.
Oui.
Madame Ashton.
C'est mon amendement, je dis non.
6 yeas, 5... 6 nays, 5 nays. Pardon. Donc, c'est défait.
Donc,
The motion is defeated, so we're moving back to the amendment. Let's speak to the speaking list for the amendment. The next person is Mr. Généreux.
Ensuite, M. Beaulieu.
And then Mr. Beaulieu. Mr. Chair, I'm extremely disappointed to see what's happening today. This government over the past 6 years has had the opportunity of bringing forward this legislation on official languages, and almost 7 years later, we are at this point. And right now, as we speak, you're trying to amend a law that has been in place over the past 50 years and which will be, once revised, in place for another 50 years. And it's actually not one bill, but 2 bills, a second bill, which hasn't been studied by anyone. So clearly, we owe this to ourselves as parliamentarians to make sure to take the time necessary to study this bill and to hear the voices of all relevant parties and stakeholders. We might have potentially associations that could be represented as a group to save some time, but there are associations that want to be heard, and we have to listen to the voices of the provinces, especially Quebec, with this bill. All of the parties submitted their list of witnesses. It will take more than 15 hours to study, to go through all that. That's my impression, at least. So I would like the Liberals want to. I mean, I see that. I understand that they want to go forward and proceed quickly, but let's make sense. Let's keep things logical, if you will. Everyone should understand that we are not in a partisan battle here. We all agree with the idea of passing this new bill as quickly as possible, but with the numbers we have in front of us, it just doesn't work. It's impossible. We don't even know if we will be sitting at some of these dates that have been mentioned. So the people watching us, witnesses that are with us today, and all Canadians watching this, I wouldn't want them to say, okay, it's just one or the other. It's still the same thing. So we have to be working in a respectful manner together, and we are working on a bill that has 50 years of age, and which will be, once amended, will be in place for another 50, possibly. But my colleague here is saying that, once passed, it will need to be modified again. I think we owe it to ourselves to do things properly within the timeline that is given to us until the end of the parliamentary session. So let's go ahead with the witnesses. Let's make headway and progress until the end of the session, and then we will pick things up again in autumn, and let's try to make sure that this bill takes its best form for all the parties. Thank you, Mr. Généreux. Just to clarify it for the deputies, Mr. Beaulieu, on this particular topic, can I move a sub-amendment? Yes. Do we have the right? Yes, you do have the right. Paragraph C, clerk invite witnesses to appear during the meetings starting from the weeks of June 6th is what I would move, and then eliminate paragraph H. Because I also think that it is important to take the time necessary. We might accuse each other of certain things. It goes both ways, but there is willingness to just bulldoze through it. I think in Quebec, the bill on the official languages has a significant impact, and it is important to do the bit of the debate that concerns Quebec, which we haven't done. Ms. Latanzio, on the sub-amendment, please correct me, Mr. Beaulieu, if I'm making a mistake, but you are talking about paragraph C of the motion, and you wanted to read, the clerk invite witnesses to appear during the meetings starting from the weeks of June 6th and June 13th, and you are moving to get rid of paragraph H altogether, right? Okay. So on the sub-amendment, going back to the speaking order, Ms. Latanzio, the floor is yours. Yes, thank you, Mr. Chair. I wanted to take the floor to read the amendment by Ms. Ashton. Can we have the clerk send it to us in both official languages? It's already sent. It's already sent. Okay, do we now focus on the amendment and then the sub-amendments later, or are we continuing with the sub-amendments? As per the procedure, we have to discuss the sub-amendment moved by Mr. Beaulieu. Could you then repeat that, please? Do you have the document, the amendments proposed by Ms. Ashton, sent by the clerk a couple minutes ago? So, off of that document, you will see in red the amendments proposed by Ms. Ashton. In paragraph C, Mr. Beaulieu is suggesting that we include starting from the weeks of June 6th and June 13th. That would be in addition to paragraph C. And paragraph H to be scrapped altogether. Yes, Mr. Drouin. Is that okay, Ms. Latanzio? Mr. Drouin and then Mr. Godin. So sub-amendment to the sub-amendment, just to clarify things, just so I understand, Mr. Beaulieu, when he's talking about the timeline, is he talking about parliamentary time or just calendar days? Because parliamentary time is the only way that we can keep having witnesses. So if you eliminate H, you're talking about parliamentary time. And to me, that doesn't make any sense. I'm just asking the question because if you want to get rid of H, H is what allows us to reach out to the whips so that we have parliamentary time, so that the committee focuses on the question, but you're proposing to get rid of H now. So I'm just trying to understand. Is it calendar days? Do you want to have the summer, take the summer to go somewhere? Okay, to keep things logical, Mr. Godin first, and then you can go. Okay, Mr. Chair, I'd like to propose a sub-amendment that within the scope of the study of the Bill C-13, just a second, Mr. Godin, we are talking about the sub-amendment. We need to finish that, and then we can continue. We have to focus on this. Are we not done with the amendment by Ms. Ashton? Mr. Beaulieu has just proposed a sub-amendment to the amendment of Ms. Ashton. Well, I'm adding a sub-amendment to the amendment by Ms. Ashton, but before that, we will have to deal with the first. That would be the correct way of doing things. Okay, Mr. Drouin, I think you were talking about paragraph H. You have the floor. Please go ahead. Okay, so what I'm bothered by is it says, as agreed to on Wednesday, June 1st, subject to the approval of the recognized parties' whips and the availability of meeting slots from the House of Commons, the committee hold as many additional meetings as possible with the goal of accomplishing a maximum of 15 hours of study prior to the beginning of clause-by-clause consideration of the bill. I think it maybe hints at limiting the debate parliamentary time just 15 hours. Mr. Chair, can I clarify my amendment? Your amendment, Ms. Ashton, so in paragraph H, so you don't want any reference to 15 hours, right? Yes. Mr. Godin and then Mr. Drouin. In Ms. Ashton's amendment, she already got rid of the last bit of the proposal. Mr. Godin, go ahead. So I would like to bring this forward for all deputies in paragraph H, as I agreed to on Wednesday, June 1st, 2022, but there was never such an agreement to include a maximum of 15 hours of study before the study began. So what Ms. Ashton is proposing, I think it is really relevant, and we cannot accept a motion that has wrong information within it. We don't even need Ms. Ashton's amendment because in the language there's a mistake. Thank you, Mr. Godin. Mr. Drouin. We are talking about 15 hours, but just to clarify, once again, how many hours do you want? Mr. Beaulieu, how many hours do you want as a committee? So that I have an idea because when we talk about the number of hours, well, committee is not going to be sitting over the summer. We're coming back towards the end of September, 4 or 5 hours towards the end of September, and then October, and then we have a parliamentary break for Thanksgiving. So then before you know it, it's December. Point of order. I think all communications have to be addressed to the President. Ms. Ashton and then Mr. Beaulieu. We're not hearing you, Ms. Ashton. I think you're on mute. I wanted to clarify something too. It's my amendment, which is being discussed right now. So we never proposed this, so thank you for that clarification. But there is willingness from our side, at least to add hours, but not to limit our democratic work here in the committee. Sorry, Ms. Ashton, what was your last sentence? So on our end, we agree with the idea of adding hours, but we cannot limit the democratic work of the committee with this specific addition of 15 hours. That's why we are proposing, while we're moving an amendment, to get rid of it. Thank you, Ms. Ashton, Mr. Beaulieu, and then Mr. Godin. So, paragraph H, I would actually keep the bit that says starting from the weeks of. So we don't want the time to hear witnesses being limited. I don't know if I have the right to do this, but I would withdraw part of my amendment that was about paragraph H. If you want to modify your sub-amendment to Ms. Ashton's amendment, that would take unanimous consent. So you would keep it as is, and then instead of saying 15 hours, what do you want to include? Yeah, so paragraph H, I would keep it as Ms. Ashton talked about it. So she proposed getting rid of the part that has a reference to 15 hours, maximum of 15 hours, but I would keep C, paragraph C, reading, starting from the weeks of June 6th. So when you say starting from, what does it change? So that we're not limited to hearing witnesses only the weeks of June 6th and June 13th. So starting from June 16th, and you would get rid of June 13th then? Yes. Yeah, that's why I was confused a couple of minutes ago. Okay, starting from the week of June 6th, right? That's it. Okay, just to clarify things, Mr. Beaulieu's sub-amendment to Ms. Ashton's amendment would be that paragraph C would read, the clerk invite witnesses to appear during the meetings starting from the week of June 6th, 2022. And paragraph H would say as is, as proposed by Ms. Ashton. Mr. Godin and Mr. President, Mr. Chair, sorry. So when it comes to the wording and towards the end of paragraph H, there is, so the clerk invite witnesses to appear during meetings starting from the week of June 6th. That would be my sub-amendment. Just a second, Mr. Godin. Mr. Godin, I didn't really fully understand the modification you want to bring to paragraph C. Okay, you said the clerk invite should be the specific language. Witnesses to appear during meetings starting from the week of June 6th. I think this is what Mr. Beaulieu was saying. Okay. I asked for a vote, and you told me I don't have the right to ask for a vote. Yeah, until the end of the debate, you don't. Okay, can we just adjourn for 5 minutes, agree on things, instead of doing this back and forth? Maybe we will put an end to this idea of coming up with sub-amendments to sub-amendments endlessly. So I am very open to suspending the session for a brief period.
We're resuming our work, so sorry for the colleagues and witnesses who are on Zoom. So we were at Mr. Beaulieu's sub-amendment. Is there any other discussion or statements about this sub-amendment? Mr. Drouin. Mr. Chair, what I would do, and I know that this requires unanimous consent, but I would withdraw the whole motion because otherwise we can debate about it, but our objectives are the same. We don't agree on the time it's going to take to do this study. We know we're working on C13. It will take the time it takes, but I can't withdraw my motion without unanimous consent, so I think we should move to a vote. So you're talking about removing the entire motion. This is the crux of the problem, so if I remove the heart of the problem, we don't have to deal with the sub-amendments. I will consult with the clerk because there's the amendment and the sub-amendment to the main motion. I think that if we withdraw the main motion, we end the debate, but let me verify.
Je commence à reculer, donc on retire à l'unanimité. Bon, voici ce que je vous suggère.
Here's what I suggest. Do we have unanimous consent to withdraw the amendment? Sorry, to withdraw Mr. Beaulieu's sub-amendments to Mrs. Ashton's amendment? And do we have unanimous consent to withdraw the amendment to the main motion? And do we have unanimous consent to withdraw the main motion that was tabled by Mr. Drouin? This would be the easiest way to move forward for all parties at the table. Do we have unanimous consent? There are questions. Mr. Gould, Mrs. Latanzio, Mrs. Ashton, any questions? You agree, Mrs. Ashton? Mrs. Ashton, you have the floor. My amendment is a reflection of my party's desire to add supplementary meetings without limiting the committee's work. We don't want to limit the timelines or the process for amendments, for example. Perhaps this is a point of clarification for the process. How can we agree to add meetings formally as a committee? Mrs. Ashton, first of all, this isn't the question at hand. Mr. Drouin says that if there's unanimous consent, he will withdraw his motion so that we can hear from our witnesses. But as there are your amendments and Mr. Beaulieu's sub-amendment, I'm asking if we have unanimous consent to withdraw everything, the sub-amendment, the amendment, and the main motion, and we start from scratch. That's what I'm suggesting, if we have unanimous consent. So here's the question. Is anyone opposed? Yes, I'm opposed. So you want to maintain the motion. So we're moving on to Mr. Beaulieu's sub-amendment. I can't speak to that. Mr. Gould, you have the floor. The sub-amendment, and then Mrs. Latenzio. I'd like to do a point of order. Something happened a few moments ago. We asked about adjourning the meeting, suspending the meeting. There were negotiations going on, but then there were 5 members that were on Zoom that didn't participate. You know what we should have done? We should have gone in camera and discussed as a whole committee. Mrs. Ashton was like me. We were blacked out. We could see you gesticulating and coming back with a proposal. We didn't participate in the debate. This isn't constructive. We're going backwards instead of moving forwards. But I'll stop on that. But I just wanted to bring that to your attention. You made a mistake there. Mr. Gould, you are absolutely right. I apologize. We weren't aware here that when we suspended the meeting, that our colleagues, our elected colleagues who were participating on Zoom were excluded. We found out after. I'm so sorry. We'll know for the next time. So, Mrs. Latenzio, on Mr. Beaulieu's sub-amendment.
I will permit myself to say the following, is that we've invited guests to appear before us today. They've been patiently waiting. I understand that the matter that we're discussing is also equally important, as the committee does want to be able to hear as many witnesses and do its work diligently on this very, very important piece of legislation. That being said, I think that discussions may well pursue beyond the time of today's committee. And I would propose at this point, Mr. Chairman, if we can please adjourn the debate and possibly leave the opportunity for members to speak to one another, perhaps after today's session, as we will reconvene on Wednesday, but to hold up the witnesses, all the time that we have at this point, I think is undue. And I think that, my proposal would probably be a reasonable one, if I can permit myself to say that at this point in time, Mr. Chairman. So I submit that to my colleagues, that we adjourn the debate on this issue and possibly take this up again at another time, but that we start listening to our witnesses who have been patiently waiting now over an hour.
Madame Latenzio, what I understand is you're proposing that we cease the debate on the sub-amendments, right? Okay, donc on passe directement.
Okay, so we're going to vote.
Rappel au règlement, Monsieur le Président.
Point of order, Mr. Chair. I made the exact same request half an hour ago. No, earlier you were speaking to the amendment. We have to finish the sub-amendment first. So she's asking that we adjourn the debate on the sub-amendment, while I was proposing that maybe Monsieur Beaulieu would like to withdraw the sub-amendment. So there's no more debate. Debate is no longer possible. We have to move on to a vote. Mr. Beaulieu, you're saying that you're withdrawing your sub-amendment. Do we have unanimous consent? Does everyone agree? I see no heads shaking. Great. Moving on to the amendments proposed by Mrs. Ashton. Mrs. Ashton, you have your hand up? No. So we can move to the vote? So now we're voting on Mrs. Ashton's amendments. No more questions. We're moving on to a vote.
Madame la
Madam Clerk.
Monsieur Drouin.
Monsieur le Président.
Oui, Madame
Monsieur le
Latan.
Président.
Mr. Chair, yes, Mrs. Latanzio. I'm so sorry to interrupt you, Mr. Chair. The request to close the debate was on the entire debate. I understand that you're going step by step and that my colleague withdrew his sub-amendment, but I would like to do the same for the amendments that have been proposed by my colleague, Mrs. Ashton. So let's adjourn the debate on this entire matter and move on to hearing from our witnesses. As I've mentioned, they've been here for an hour and have been waiting very patiently. Thank you, Mrs. Latanzio. This is the end of the discussion. So on Mrs. Ashton's amendments, there's no more debate. We are now ready to vote. Mrs. Clerk.
Vous votez présentement pour
You are now voting on adjourning the debate on Mrs. Ashton's amendments.
OK. Oh là là.
Okay. I'm getting myself mixed up in the procedure. Mrs. Patricia Latanzio, we had voted on proceeding and it was defeated, and we can't go back on that. So now we're back on Mrs. Ashton's amendments. So the amendments are adopted. No, so we have to vote on the amendments. We're voting on Mrs. Ashton's amendments. I would like to adjourn the debate on Mrs. Ashton's amendments. Mr. Godin, we have already decided and voted on these amendments that would get done. But she's modifying your motion. Mr. Godin, the first vote was about Mrs. Ashton's amendments, and we voted to keep them 6-5. And now we continue the debate. But now I am proposing that we adjourn the debate. We've already put that question, and it was defeated earlier in the meeting, so you can't vote on the same thing again. I trust you, Madam Clerk. Mrs. Latanzio. Are we continuing the debate, or are we moving to a vote? Mrs. Latanzio, no question. Mr. Beaulieu. I wanted to come back on point C. It says here that the clerk invites witnesses to appear in the weeks of June 6th and June 13th. And it doesn't say only those weeks, so that doesn't mean that we will stop hearing from witnesses after that.
La greffière
C'est ça que
fixe
je
la
l'ai enlevé, parce que dans le fond, la greffière...
It says the clerk invite witnesses to appear during meetings on weeks of June 6th and June 13th, so it's just those 2 weeks, right? So, but it doesn't exclude that we can continue hearing witnesses after. Mrs. Latanzio, you had your hand up. No? Okay, sorry, Mr. Godin. Mr. Chair, I simply want to ask the question to our clerk. I feel that there is a willingness around the table to withdraw with unanimous consent the amendments, but Mrs. Ashton did not agree to that. But when we are done with the amendments, discussion on the amendments, we will come back to the motion. Okay. Okay. Other questions on the amendments, Mr. Drouin? No? We're going for a vote, Madam Clerk. So the vote will be on Mrs. Nikki Ashton's amendments.
Monsieur Iacono.
No.
Madame Kayabaga.
Vote contre.
Madame Latanzio.
Against.
Madame Lalonde.
Non.
Monsieur Godin.
Oui.
Monsieur Gourde.
Oui.
Monsieur Lehoux.
Oui.
Monsieur Généreux.
Quelqu'un qui s'en occupe. Oui.
Monsieur Beaulieu.
Ça dire oui.
Madame Ashton.
Oui.
Pour 6, contre 5. Oui, modifié.
OK? Et là, on vote.
On peut rediscuter.
Donc,
So, a procedural question. We're going back to the main motion as amended by this vote.
as amended by by this vote. OK? Donc, est-ce qu'il y a d'autres discussions par rapport?
Is there going to be any other discussion? Anyone else who wants to take the floor to the main modified motion? I would like to adjourn the debate, right? Now I have the right to ask for it, no? Madam the Clerk? So the vote will be on adjourning the debate on motion as amended.
Monsieur Iacono.
En faveur.
Madame Kayabaga.
En faveur.
Madame Latanzio.
In favor.
Madame Lalonde.
Oui.
Monsieur Godin.
Oui.
Monsieur Gourde.
Oui.
Monsieur Lehoux. Monsieur Généreux.
Oui, puis ça presse.
Monsieur Beaulieu.
Oui.
Madame Ashton.
Oui.
La motion est adoptée.
Okay, thank you. The motion is adopted as modified. Now we are going back to our witnesses. Just a second, Mr. Godin. And then Mr. Beaulieu. And then we need to carry on with the witnesses. Mr. Chair, I have a motion to table about C13. I will try to find that within the framework of the study of Bill C13, the committee give instructions to the clerk to invite the premiers of provinces and territories to hear from them and to include their voices in for the purposes of this current study on C13. Okay, thank you, Mr. Godin. The clerk is distributing the motion as read. Yes, Mr. Beaulieu.
C'est l'ajournement.
L'ajournement.
C'est beau, excusez. Je n'avais pas compris.
Mais l'ajournement. Oui. Monsieur Beaulieu, l'ajournement qu'on a fait.
Mr. Beaulieu, the adjournment was about the main motion as amended. So the debate on the motion is adjourned. Okay, so Mr. Godin's motion, are there any questions about this motion? Yes, Mr. Drouin. I'm reading the motion with attention. I don't have an issue with it. but I don't see the usefulness of inviting premiers. The Premier of Quebec has been focusing on this topic, but we will support this motion. But just to remind all Canadians who are following this debate, they are free to come forward with as witnesses, and they don't need anything else to do that. Any other questions? I don't see any hands up on my screen. Okay, do we have unanimous consent to accept this motion? I'm not seeing anyone who is making negative gestures or around the table. Okay, the motion's thus adopted. Okay, what I suggest we do for the remainder of our meeting is that we can let the witnesses for the second hour know that we will invite them at a later point in time. Okay, with that being said,
On me dit que tout le monde.
okay, so everyone is already online and connected to the meeting, the panelists for the second hour. So we'll carry on and with all the witnesses then. Okay, with that, from QCGN, Ms. Jennings.
QCGN, Marion Sandy Lanes Council, ainsi que M. Michel Doucette, professeur émérite.
As well as Mr. Michel Doucette, Emeritus Professor, Faculty of Law, University of Moncton, and then Janice Neymark, lawyer. So I will give the floor to you. You will have 5 minutes to make your presentation, and then we'll open the floor for questions based on the list we have. So, Mrs. Jennings, you have 5 minutes. Thank you, Mr. Chairman.
President of the Quebec Community Groups Network. I am joined today by QCGN board member and former senator, the Honorable Joan Fraser, and our legal counsel, Maître Marion Sandilands. Thank you for the invitation to appear in your committee's study of this seminal legislation. Committee members have received the QCGN's brief, so we will focus our opening comments on the essentials. Le QCGN est fier de soutenir la...
The QCGN is proud to support the protection and promotion of the French language in Canada. No other English-speaking community in the country can claim to have our level of bilingualism and mastery of the French language or demonstrate the personal commitment that this implies. The QCGN recognizes the demographic decline of Francophone minorities outside Quebec. In fact, our organization actively supports the protection and advancement of language rights, continuing a long tradition of court interventions on behalf of Francophone minority communities. Before addressing Bill C-13, I must mention a related law, Bill 96, which was recently passed in Quebec. This law weighs heavily on Quebec's English-speaking community as it transforms the Charter of the French language and protects it under the Notwithstanding Clause. In addition, it purports to amend the Constitution Act 1867. It makes clear inroads into federal jurisdiction and into constitutionally enshrined language rights. Its application will have profound consequences for Quebec's English-speaking community in terms of public services, education, and access to justice. In our view, this committee cannot study Bill C-13 without knowing and understanding Bill 96.
QCGN has studied Bill C-13. In our brief, we set out 4 strategic concerns. 1, the revolutionary change in the purpose of the Official Languages Act and the effects this may have on the interpretation of this quasi-constitutional law. 2, the references to the Charter of the French language, which, as amended by Bill 96, operates notwithstanding the Canadian Charter of Rights and Freedoms. 3, the failure of Bill C-13 to address the well-known accountability challenges surrounding Part 7 of the OLA. And finally, 4, the historic proposition of creating new language rights in federal legislation for only one official language, initially in only one province. I would like to express our community's profound disappointment that the federal government would recognize the Quebec Charter of the French language as amended by Bill 96 within the Official Languages Act. Bill C-13 proposes to include 2 references to the Charter of the French language in the Official Languages Act, and in addition, proposes to allow federally regulated private businesses to choose to be subject to the Charter of the French language. It is the only provincial language regime to be so honored, but I repeat, it operates notwithstanding the fundamental rights and freedoms guaranteed in the Canadian Charter of Rights and Freedoms. It beggars belief that the Government of Canada would contemplate recognizing such legislation. The QCGN strongly recommends that all references to legislation that operates notwithstanding the Charter of the Canadian Charter be removed from Bill C-13. I turn it over to my colleague, Joan.
30 seconds.
We have 30 seconds. I will start. Jusqu'à présent.
There we go. Jusqu'à présent, mais
Until now, the Official Languages Act was intended to make Canada officially bilingual, to give life to constitutional language rights, and to enshrine federal obligations with respect to Canada's official languages.
First on the official language of government, and from 1988 on advancing the equality of status or use of English and French in Canadian society. Bill C-13 radically changes that approach. It has as its central purpose the protection and promotion of only one official language, French. C-13 embraces asymmetry in the relationship between Canada's 2 official languages. This approach was expressly rejected by the B&B Commission. It is offensive to the Constitution and antithetical to the principle of linguistic duality in law. Asymmetry is appropriate in the practical application of the
Mrs. Fraser, sorry to interrupt. We have more than 5 minutes that just passed on. We'll continue with the questions after a while, and you can answer through the question. If not, I'd like to remind every witnesses that they can provide any written information that they think would be of great importance for the committee. So right now we'll wait for the questions, but just before, I'll pass on the 5 minutes opening remark to Maître Michel Doucette de la Faculté de droit de l'Université de Moncton. Monsieur.
Mr. Michel Doucette from the Faculty of Law, University of Moncton, you have 5 minutes. I'm not seeing them. Do you hear me? Yes. I am not with the Faculty of Law of University of Moncton. I retired a while ago, so I'm working on my own behalf. So I'm not going to be representing any institution, any faculty or organization, so this will be a personal intervention. First of all, I'd like to thank the members of the committee for inviting me to make a presentation this afternoon on a subject that is close to my heart and to which I've devoted a great deal of my adult and professional life. Those who know me know the interest I have in the protection of language rights in Canada in general and in New Brunswick in particular. Canada's Official Languages Act, as well as that of New Brunswick, play an important role in the development and vitality of minority language communities, particularly French-speaking communities that are in a minority situation, not only in their provinces, with the obvious exception of Quebec, but also at the national and continental levels. These communities need both the federal and provincial governments to be aware of their fragility and the need to actively support them if we want to ensure their sustainability. So it goes without saying that the recognition of rights for a minority language community comes with an essential obligation. It must promote the achievement of substantive equality. This community must be able to claim different treatment from the majority in certain circumstances so that its particular needs are taken into account. However, the notion of substantive equality is often misunderstood. Language rights are often seen as a response to a request for accommodation. In such an interpretation, these rights are limited to the right to communicate with and receive services from public authorities in the official language of one's choice. This view has the effect of instrumentalizing language rights. It ignores the need for language security of the group, one of the fundamental reasons for recognizing these rights. The main purpose of language rights is to promote the growth and development not only of the individual speaker, but also of the entire community of speakers. If this were not the case, we might rightly question the compelling need to recognize such rights. Since, as a general rule, individual members of the minority community can express themselves in the majority language, what use would language rights be if not as mere accommodation tools for those isolated cases where a person is not able to speak the majority language? Consequently, language rights must necessarily serve to promote both the primacy of the progression of official language minority communities towards real equality and their sustained development and full blossoming in political and social harmony. I am aware that this recognition alone is not enough to change mentalities, nor can the law alone ensure the survival of a linguistic community. This decisive role belongs rather to the members of the minority language community. It's up to them to assume this responsibility. It is up to them to ensure that these rights are respected. So having said that, I will of course have the opportunity to respond to your questions about the Bill C-13. But before that, I would like to go ahead and say that this bill represents a step in the right direction. Yes, it can go further on these issues, but as Montesquieu says, perfect is the enemy of good. So, recognizing diversity of language regimes and rights will go a long way in terms of underlining the use of English and French in the Canadian society, and of course the linguistic specificity of New Brunswick needs particular attention. Just as an example, I will hopefully have the opportunity of going into the appointment of a bilingual Lieutenant Governor General in New Brunswick. This is a positive step in the right direction. So Section 16 of the bill applies to the Supreme Court of Canada, but this modification alone will not be sufficient in terms of achieving a bench at the Supreme Court with lawyers capable of understanding both official languages. So this engagement needs to be kept alive, and we need concrete and effective action. Federal government and provincial governments have to take action in order to support French-speaking communities across the country. Thank you, Mr. Doucette.
Des questions.
Thank you, Mr. Doucette. You'll be able to finish with your questions.
It's Neymark for her introduction. Mrs. Neymark for 5 minutes.
Thank you. Given the short delay between my invitation and this appearance, I have prepared my speech in English, mais soyez assurés que je suis confortable à prendre et à répondre à vos questions en français aussi. I have also prepared a letter to this committee, which I will send to the chair later this week, in which I will more fully introduce myself, expand upon the points I will highlight today, and respond in more detail to any questions you may raise. I appear here as an individual and not the representative of any organization. I was a member of the expert panel that made recommendations on official languages last year. And I am certainly not what people like to refer to as an angry phone, a derogatory term used to ridicule members of the Anglophone community so that their concerns don't have to be taken seriously. I am here to discuss the importance of symmetry in official languages, the rights of minority language communities in each province, and procedural fairness in the application of the laws created or amended by Bill C-13. The recent adoption of Bill 96 in Quebec has struck a significant blow to the English-speaking community in Quebec and has prompted many of our younger members to seriously contemplate moving out of the province after many years of relative linguistic peace. Some have already put those wheels in motion. The rights and vitality of our community are under threat, and the adoption of Bill C-13 could not come at a more sensitive or difficult moment. Our community looks to the federal government to protect its rights and assure us equal treatment as a minority language community in Canada. While I certainly recognize that the French language is in need of protection in Canada, especially outside of Quebec, given the overwhelming use of English in North America, it must still be recognized that the Anglophone community in Quebec is, in fact, a minority language community itself, which is also in need of protection by the federal government. Not because English is threatened in North America, but because the survival and vitality of our community are far from certain, and we are Canadians who deserve equal rights within our own country. I will move directly to my 3 areas of comment. First, the Quasi-Constitutional Official Languages Act has special status over other legislation. It can be used to interpret other federal laws. The Official Languages Act, like the constitutional provisions it brings to life, has always enshrined equal treatment of minority language speakers, and that thread is carefully woven throughout the Act. As mentioned by others, Bill C-13 affects a dangerous paradigm shift involving moving the Official Languages Act from a carefully crafted, well-balanced act that recognizes 2 official languages and 2 minority communities to an act that promotes unequal linguistic rights for its citizens based on their language and location. I am also very troubled by references to the Quebec Charter of the French language in Bill C-13, thereby blurring federal and provincial spheres of competency. Most egregious, however, is that this charter, as amended by Bill 96, purports to operate notwithstanding constitutionally protected fundamental rights and freedoms. By including references to the Charter of the French language in the Official Languages Act, the federal government is supporting and implicitly legitimizing Bill 96, a law about which the Minister of Justice, David Lametti, recently indicated he had concerns and even certain fears. These references simply cannot be allowed to remain in the Official Languages Act. As regards the French and Federally Regulated Businesses Act, the problem here is that it treats the English as the language of the majority, but ignores the reality that English-speaking Quebecers are themselves a minority language community. These provisions, insofar as they apply to French language minority communities outside Quebec, will promote the use of French in those regions and be positive for the rights of such communities and their members. But in Quebec, they will instead be positive for the rights of the majority language community and detrimental to the rights of the minority language community and to its members. This act will eliminate jobs for Anglophones and reduce the services available to them in English in Quebec. It may also backfire and result in an exodus of federally regulated businesses from Quebec, given how easy it is to relocate in today's virtual world. Businesses will choose the path of least resistance, the least costly means of operating. If a business in Quebec is required to have certain materials available in French, but also permitted to have them available in English, the English materials will disappear over time. If a business is required to hold meetings and create internal communications in French, but also be permitted to do so in English, the number of employees who prefer to communicate in English will be reduced through attrition. If a business is required to provide services in French, but also be permitted to provide them in English, all the while restricted from making knowledge of a language other than French a job requirement, they will simply stop hiring non-Francophone employees. And while most of the young people in the English-speaking community in Quebec are functionally, if not fluently bilingual, this will reduce the job opportunities available to them. I will skip over my comments about fairness in the Official Languages Act, procedural fairness, and you will find those in my letter to the committee. My letter will contain
Mark, please. Can you wrap it up, please?
Yep. My letter will contain a number of recommendations, and here I will highlight 4. First of all one-sided provisions in the Official Languages Act that only promote and protect the French language should be eliminated. Alternatively, wherever C-13 refers to the protection and promotion of the French language, the words "without causing undue prejudice to the English language minority community in Quebec" should be added.
Okay, merci
Secondly,
beaucoup.
all references...
Thank you very much.
Thank you. We'll proceed with question, and maybe you can answer, continue your remarks through the answers you could get for question that you could get. Je commencerai la session.
I'll start the question and answer period with 6 minutes for the first questioners. We will start with the first vice chair of this committee, Mr. Joël Godin. You have 6 minutes. Mr. Chair, thank you, and thank you to the witnesses for your patience. We apologize for what happened earlier in the meeting, but this is the reality of parliamentary life. I'm sure you understand. We all have to debate our convictions and our ideas. My first questions are for the QCGN. I would like to hear what you have to say about what you're seeing on the ground. What's the situation of French and English in Quebec? And I apologize in advance. I might have to interrupt because my time is limited.
Un instant, je vais juste...
One moment, please. The situation in Quebec. I'm so sorry. I'll ask you a more specific question. Is English gaining ground in Quebec, or is French gaining or losing ground in Quebec?
On se rapporte au rapport de l'Office.
There's a report from the Office québécois de la langue française that was published in 2021. They noted that there was an increase of other languages being used in Quebec, but no decline of French in the public sphere. These reports from the OQLF demonstrate that in terms of immigration, French is coming out on top. For children of newcomers to Quebec, the results are going in the same. Mrs. Jennings, thank you for your answer. That is enough for me. The Commissioner of Official Languages, do you agree with us that we should give him more powers as to Part 7 of the Act? Yes, and in our memoir, we stated that Part 7 should be reinforced. The Official Languages Commissioner should have more powers. We totally agree with that. As for linguistic dispositions, are you comfortable that about linguistic clauses being negotiated respectfully with the provinces and territories, but understanding that the federal government has the responsibility of making these be respected? Do you agree with their inclusion as in C13 as an amendment? Yes. This is something that the QCGN has been talking about for years. Until now, agreements between the province and the federal government did not include this type of disposition. We would be in favor of this. You stated in your opening remarks that only one official language exists in Quebec. Can you elaborate on that? Because when I walk the streets of Montreal, that's not the sense that I get. You know, I turned 70 in November. The interpreter would like to signal that there is an echo. I can say that the status of the French language and other languages hasn't really changed in Montreal. Anecdotally, if we look at serious demographic studies, we can see that the use of French in the professional sphere has increased. We also see that the use of French in the public sphere as a common language has increased. The only place where we're seeing a decline of French is in its use at home. Thank you, Mrs. Jennings. So according to you, French is not in decline in Quebec. That's what I believe I understand. That is not what I said. I said that according to the reports produced by the OQLF, yes, thank you, Mrs. Jennings. I'm so sorry. I must interrupt. I received your answer and I will interpret it as I see fit. Thank you very much. My next question is for Mr. Doucet. Mr. Doucet, you talked about the necessity of protecting minority groups. Can you elaborate on that? Of course, my position is slightly different from that was presented earlier. I think that one of the most important dispositions of C13 is the protection of French. We know that French in Canada is vulnerable in the provinces. One thing I've said more than once is that minority language communities outside of Quebec are forgotten within the debate between Anglo-Quebecers and Franco-Quebecers. The linguistic debate in Quebec is important. It's kind of a debate between two majorities or two minorities, depending on the lens you take. But the problems in Quebec are not the same as the problems faced by Francophone communities outside of Quebec. Mr. Doucet, thank you, Mr. Doucet. Quick question. Do you think C13 should be amended to force the lieutenant governors and Governor General of Canada be bilingual with English and French? Absolutely. And I think that if at the federal level we believe it goes against the Constitution, we can submit the question to the Supreme Court so that they can make a decision. But I think that this is a small modification we could bring to the Act, and we should make sure that the person who is selected by the committee should be bilingual. We can take New Brunswick as an example. Thank you, Mr. Doucet. Thank you, Mr. Godin. Next round of questions with 6 minutes is Angelo Iacono. Thank you, Mr. Chair. Thank you to the witnesses for being there today. Mrs. Fraser, why do you recommend that the minority should be determined per province or territory? In part, according to the copy in C13, there is an ambiguity between the idea of a linguistic community at the federal level or regional or provincial level. You'll find more detailed discussion of this in our memoir. We believe it's important that in a constitutional bill like this one, it's important to be as clear as possible. What are the legal implications, legally, of such a definition? I'm not a lawyer. Perhaps we could ask our legal counsel to give you a response. Of course, we would like to avoid problems. If we have a national Francophone minority, we want to avoid confusion between the supports that are provided for minority linguistic community in each province, which is why it's so important to define these communities. And we want to avoid, we don't want to forget that French is a minority language within Canada. So we need a clear definition of minority linguistic communities in each province. Inaudible to the interpreter because the microphone is not selected.
Officielle en situation minoritaire.
Premièrement, le QCG.
The QCGN would like to see this program made permanent. That way, it would be difficult to remove it, as has happened in the past. I'd also like to open a small sidebar to say that the QCGN supports the comments that were made by Mr. Doucet when he was speaking about the need to support Francophones outside of Quebec. Often, these minority communities are forgotten and left out of the debate. We think they should be at the heart of the debate. We think that the legal contest program should be made permanent and that the money that is allocated to it should be increased significantly. Anyone knows that building up such a case, as we saw with the British Columbia Francophone case, is that the amounts were above $1 million. So we don't have sufficient funding for these types of programs. Thank you. The next question will be for another witness. The fact that Quebec is majority Francophone in Canada, many people have testified to the decline of its use to the profit of English. However, in Quebec, Anglophones are the minority community. So according to you, which compromises can be made to have dispositions to protect and promote official language minority communities while protecting and promoting French? Mr. Doucette. I will let people in Quebec respond to this question. I think that there are enough problems outside of Quebec for Francophone communities without forcing us to answer this question. Mrs. Jennings, I would like my colleague, Honorable Joan Fraser, to respond to this question. I believe it is possible to promote, encourage, and enrich the use of French in Quebec without limiting Anglophone communities. For example, there are dispositions in C13 in the new part about private companies that state that services must be provided in French. They can be provided in English. I believe that for federally regulated companies that are under federal jurisdiction, it would be desirable and coherent with the idea of official languages rights that services should be offered to Francophone clienteles. But if a citizen is asking for service in English in these companies, they should be able to access them. For French as a second language, for people who come here from outside. Thank you, Mrs. Fraser. The next questions will come from the second vice chair of this committee, Mr. Beaulieu. You have the floor for 6 minutes.
Première question va.
Thank you, Mr. Chair. My next question is for the QCGN. You said that Bill 96 was the perfect formula to eradicate the English community in Quebec, and you made a parallel between Bill 96 and the invasion of Ukraine by Russia. Do you not think that that's an exaggeration? Inaudible to the interpreter. Your microphone is not on, Mrs. Jennings. Is this Mr. Beaulieu that posed the question? Yes. If you had read the tweet that I sent congratulating Premier François Legault for his clear support to the Ukrainian people against the invasion, the horrific invasion by Putin, how he was celebrating how Ukraine was defending democratic principles, I asked him the question, then why suspend fundamental rights guaranteed by the Quebec Charter and the Canadian Charter. I sent him another tweet after that saying that I had perhaps expressed myself poorly, saying that I had perhaps expressed my inaudible. So thank you for recognizing that you expressed yourself poorly. When you talked about the eradication of the Anglophone community, were you also misspeaking? No.
Définitivement non. Parce que je ne parlais pas.
No, because I was not speaking about the English language. I was talking about the English-speaking community, the minority, official language minority community. But you were talking about them being eradicated. Well, when you squeeze out the employment opportunities or when you restrict access in English to services offered by the state, and when you... Mrs. Jennings, I don't have a lot of time for my questions. You're not responding to the question. What can be done is, if the time is so limited, then the QCGN will actually be able to respond in great detail to our questions. I have another question to you, Mrs. Jennings. Do you agree with Quebec being a minority in Canada? Yes. So you should agree on the following as well, then. The Human Rights Council of the UN, when a majority group within Quebec represents a minority in the country in which it finds itself, in that case, the Anglophones cannot be considered a linguistic minority because the Anglophones in Quebec are part of Quebec. So the Quebec and Quebec majority englobes them, if you will. The law on official languages and the Act on Official Languages recognizes two official languages, and English and French-speaking communities, minority communities everywhere in Canada. So there is an act, which is a quasi-constitutional act, the Act on Official Languages. You're saying in your own written submission that the Charter of the French language is not compatible with the political objectives of the Act on Official Languages. So to ensure and guarantee the future of French in Quebec, you have to integrate the newcomers. The government is saying that 90% of transfers, linguistic transfers, will be towards French. But you're saying that you will, when you use the criteria of the first official language spoken, then you include the new arrivals to Quebec who speak English and whatnot, and they have to be Francicized to be able to integrate in Quebec. So French would be the common language in that case. No, Mr. Beaulieu. First of all, what we're saying is that the Charter of the French language, as amended by Bill 96, which has now become an act, was incompatible with the Act on Official Languages, which is a quasi-constitutional act. And the reason why we said it was incompatible, we are almost out of time. Quebec is trying to make French the only official language to integrate the newcomers, and the Act on Official Languages refers to two official languages, so it prevents this integration. Thank you, Mrs. Jennings. That's all the time we have. 6 minutes isn't that long. So with that, the floor is over to Mrs. Ashton. Mrs. Ashton, you have the floor for 6 minutes. Thank you, and I'd like to welcome all of our witnesses. I will ask my questions to Mr. Doucette. The sound quality, it does not allow the interpreter to carry on interpretation. The interpretation will resume as soon as the sound quality is improved.
les provinces et les territoires, elle pourrait avoir un impact considérable sur l'offre de services en français à travers le pays. Si des clauses linguistiques avaient été négociées pour offrir des services d'éducation à la petite enfance, aux francophones et aux francophiles à travers le Canada...
Madame
on aurait
Ashton,
pu-
sorry to stop the clock. Technicians are telling me that your mic doesn't work well, and they're suggesting that you should unplug your mic and plug it back. And don't worry, I stopped the clock.
Est-ce que c'est mieux comme ça?
Oui? Beaucoup mieux. Allez-y.
Oui. Ah, OK, super. OK, alors, si des...
So, had linguistic clauses been negotiated to offer early childhood services to francophones and francophiles across Canada, we could have modified, for instance, in a sustainable manner the social fabric in Canada and establish bridges. The challenge we have here in Manitoba, for instance, is about finding sufficient place to be able to send their kids to early childhood services centers in French, for instance. Do you think that the government should systematically negotiate linguistic clauses with the provinces and territories when it comes to agreements of this sort? Absolutely. I think it's essential that the federal government makes sure especially the English-speaking Anglophone provinces of Canada should respect Francophone communities. Early childhood is critical. I was saying this in the 90s. It is crucial for Francophone communities outside of Quebec if you want to have tools of this sort that will then allow access to childhood facilities, early childhood services in the French language. If we're not making those steps, then the fight for Francophone minorities might be lost. So the federal government has to make sure that there is sufficient funding for Francophone communities, and this funding is used for these purposes, not for something else. And we have to have clauses, yes, but we have to make sure that these clauses are binding on the provincial governments, and so that these governments are under the obligation of using these amounts of money, this financing in this way. Thank you for your answer. The Commissioner for Official Languages still doesn't have the power of issuing orders under Part 7 of the Act on Official Languages. Do you think that the Commissioner of Official Languages has the sufficient tools in their toolbox to be able to do their job? So what do you think about these powers under Part 7? Absolutely. Part 7, again, essential. Part 7 for a long time has remained as a provision not enforceable in courts. I've taken similar matters to courts, up to the Supreme Court, and there has been an amendment to make it, to correct it. But yes, we owe it to the Commissioner of Official Languages to have the power to oblige different institutions to implement these positive steps, and we have to expand the scope of these orders as well, as per the new Part 7. So, institutions have a tendency of forgetting their obligations under Part 7. So if we were to take this step, then this would be a positive step for the official languages in Canada. Mr. Doucette, you suggested in the past that the Commissioner for Official Languages should have the power of issuing administrative fines. Do you think this authority needs to be expanded in relation to what's proposed under C-13? At one point in time, I sincerely believed that the power to issue administrative fines would be a way of pushing institutions to obey the requirements of the Act. These sanctions, these monetary sanctions, if these are only symbolic in nature, that's one thing. But issuing orders to set deadlines and making sure that institutions follow the rules is going to be more important than the mere capacity of imposing monetary sanctions. It's just symbolic. It's not this fine, this amount, which will really push different institutions to abide by the provisions of the Act on Official Languages, but I have a lot more hope in this other tool, which are the orders on for institutions. Thank you. During the pandemic, everywhere across the federal government, we've observed significant shortcomings when it comes to communication of federal government organs with the public in French. Do you think we need a central agency to rectify situations like this? Do you think that the Treasury Board should have this capacity as the central agency? Yes, I think the Treasury Board should have this role of a central agency. But as I was saying, we can have the best law, the most beautiful law you want, but we also at the same time have the Prime Minister and other ministers who should be sending out the same messages. Yes, I do believe in the importance of having a central agency, but a clear leadership is also very important at the level of the federal government when it comes to the politics of it, so that people respect this act, because otherwise it will be just the little foot soldiers, if you will, in different departments. Thank you, Mr. Doucet. Thank you, Mrs. Ashton. We will have a short second round. Mr. Gaudin, I have a proposal to the committee. Would it be possible to extend the meeting by 10 minutes? No, we cannot. We will try to maximize the remaining time. Why can we not do that? We don't have interpretation services available. So, okay, a round of 3 minutes. This will be quick. Representatives of the Liberal Party and the Conservative Party, 3 minutes, and then minute and a half for the two opposition parties. Mr. Généreux. Mr. Chair, thank you. Mrs. Jennings, the Bill C-13 as amended, do you think it has the risk of being brought before the court? And if you think so, what would be an example? I will pass the question to my colleague, my lawyer colleague. We cannot really know or say what will happen in the future. That will be all the commentary I have. Mrs. Newark, do you think that the Quebec Community Group Network, do you believe that the powers of issuing orders under Part 7 should be extended? I don't have any comment on that. That's really not my field, and I'm not part of QCGN. Maybe there was confusion on your end. As the QCGN, that's what I said. Maybe I misspoke. No, I don't have any comment on that. Mr. Doucet, you spoke about the bill, about some shortcomings of the bill in different media outlets. What are these shortcomings, and what would be some amendments you would bring to the act? Yes, in the little document I had the time to prepare over the weekend for the committee, I touch upon this briefly. For instance, Section 16, that is in relation with the Supreme Court of Canada, it doesn't really have the teeth to make sure or accomplish the intended objective. We might have 5 judges, bilingual judges, when francophones are appearing, and then you can have 9 judges in other cases. So this is one of the things that can be changed. And as I was talking about a modification and amendment that could be brought to making sure the lieutenant governors, for instance, in New Brunswick, will be bilingual going forward in the future, so that this is another amendment that could be added. So changes like this could be made to the bill. I'd like to underline that the act or law in general, legislation in general, is important, but you can have the best act there is. But if you don't have political discourse and political willingness, then nothing changes. So it is in this light that I would like to underline once again that we need leadership, political leadership, and we have to be aware of the enormous challenges that different linguistic communities are faced with across Canada. Their sustainability is in question. Okay, for 3 minutes, Mrs. Latanzio. Submit
for consideration, seeing that the witnesses have been cut off for an hour, maybe we can reconvene them for another hour. My question is to Ms. Jennings, since C13 includes the reference to the Charter of the French language specifically, can you elaborate on the effects of the recent adoption of Bill 96 on the English-speaking Quebec and how it ties in with those concerns?
Well, you only have 3 minutes for the question and answers. Clearly, I would not be able to provide a fulsome answer to that. I can highlight a number of things, which is one, it puts restrictions on or makes it extremely difficult for employers, and that includes in public institutions, to hire individuals who speak a language other than French. It reduces the level of services, both in the health and social services sector. It makes access to services in English, in justice, much more difficult. It's put a cap on the student enrollment in the CEGEPs. There's a whole list.
So maybe just for, and I don't mean to cut you off, but maybe you can provide all of this in writing as I go on to the next question.
Will do.
All right. So you said that Bill C13 does not go far enough to fix the historic problems of Part 7 of the Act. Can you please provide specific recommendation on how you think Part 7 should be amended? And my last question is more of a judicial one. What impacts would recognizing a provincial law, such as the Quebec Charter, and a federal act have on the interpretation of the latter? And could this reference negatively affect the interpretation of the recognized rights of Quebec's Anglophone communities?
Excellent questions. I'm going to ask Maître Sandilands to respond.
50 secondes.
Thank you. I'll start with your second question first. Legally, the impacts of acknowledging the Charter of the French language in federal legislation are simply not known. Could they negatively affect the rights of English-speaking Quebecers? Yes, they certainly could. On Part 7, we've expressed two main concerns, and our recommendations 4, 5, 6, and 7 speak to the improvements that we're asking for in Part 7 to make it legally enforceable, number one, and number two, to make it work better for English-speaking Quebec. Those are elaborated in our brief.
Thank you.
Merci, Madame Natanzio. Nous allons passer maintenant au Bloc québécois.
Thank you, Ms. Natanzio. Now, Bloc québécois, Mr. Beaulieu, minute 30. Thank you very much. My question will be for Mrs. Jennings. Do you think it is acceptable? Well, because the federal government thinks that Anglophones are the minority, official language minority in Quebec, as so 100% of the financing of official languages financing are destined towards, are targeting the Anglophone community in Quebec. But that's not the case. It is the case, or more or less. It is, for instance, your organization, you receive maybe $1 million per year, and then the other programs, access to justice in the official languages program, etc. So, for instance, French schools, or the promotion of teaching English to Francophones. Otherwise, everything else is on the Anglophone side of things. Right now, the application of the Official Languages Act is asymmetrical, and it's completely appropriate. For instance, in 2018,
for official language programming was $308.88 per official minority language minority citizen. It was $48.65.
Excusez-moi, là je parle du Québec.
Mrs. Jennings, that will be all. Thank you. I'm sorry, minute 30 was all the time we had, but you can submit your responses in writing. So the last intervention, Mrs. Ashton, for a minute 30, please. Yes, thank you. I'll have a question for Mr. Doucette. Over the past weeks, we heard from many witnesses, including from people from New Brunswick, who talked about Francophone immigration, which as a survival issue. Do you think that the government should adopt a real Francophone immigration policy by working with organizations such as the Société Nationale de l'Acadie, organizations with ties abroad, and promoting the respect for official language minorities? Well, you put it really well. I couldn't have done a better job myself. Yes, Francophone communities need additional support when it comes to immigration. It is really a question of survival for these communities. In New Brunswick, for instance, newcomers here are integrating for the vast part to the English-speaking community, the Anglophone community. So we are not reaching these levels at the provincial level or the federal level. Even a 4% target or a 33% target in New Brunswick is not sufficient to be able to keep the demographic weight of the Francophone communities. We would need to inverse the numbers if you want to achieve this. It should be much higher than 4%. So if we believe in the survival of the Francophone community everywhere in Canada, then the federal government and provincial governments take this seriously.
Thank you, Mr. Doucet. Thank you, Mrs. Ashton. I know we were a little bit rushed for the witnesses. There are days like this where our work as parliamentarian is to deal with motions, and I'm so sorry, but this is part of parliamentarian life. Dear witnesses, I invite you to send us any additional information you deem important. Share it with our clerk, the committee clerk, who will send them to us immediately. We invite you to do that if there's important information that you think we should have. Thanks again. We must leave because there's another committee in this same room, and the meeting is therefore adjourned.